trade secret protection, think about that thing which would be terribly harmful to your business if it was known publicly. What would really disrupt your operations and make things difficult for you if it was publicly known? That's the type of information that is subject to trade secrets. A couple of things to keep in mind. It's got to be a secret, okay? It has to be valuable to the business, and you have to take steps to ensure its secrecy, okay? Non-disclosure agreements, limiting access in the lobby, making sure people can't come and go. You have to take reasonable steps to do this. The example that we go through in law school is, I think it was DuPont built a polyester plant back in the 70s, and a competitor purchased a charter plane to go over the plant and to take pictures of it as they were building it. Because if you get a chemical engineer up there and kind of, you know what capacity is, you know what the inputs will be, well, the court said, you know, that's a trade secret. We can't expect DuPont to put a tarp over a, I don't know, 100,000 square foot space. It was larger than that, but that's sort of one way to think about it. It has to be reasonable under the circumstances. If you have a device that in and of itself isn't new, but the way you make it is, you should limit access to that process in a objective way, okay?
Are these rights provided kind of inherently, or is this something that you have to come and get protected?
For trade secrets, there are provided, and I'll say this, I hesitate a bit. The law provides the right to sue based on trade secret misappropriation, okay? There are state rights and there are very recently federal rights. So if I have, 5 years ago, if you had businesses in California and on the East Coast, you would have to decide, well, do I want to sue for trade secret misappropriation in New York state court or California state court? Now you can file suit in federal court in whatever jurisdiction makes sense. So the rights are really based on the infringement of it, and they set out some boundaries. But there's nothing affirmatively you have to do to have trade secret protection other than ensure that you maintain its secrecy. And once it's gone, once there's no more secret, it's published, there is no trade secret rights.
As far as the example that you gave, there was no way they could reasonably secure that site.
Yeah.
So then they still had rights. They
still had rights. Okay, and that's a pretty extreme, I think, example, rightly picked in law school settings. But I've seen companies do a couple of things to help secure trademark protection, and this touches on patents as well, because there is a related issue in the patenting context. I've had clients decide we don't want patent protection, we want to maintain this as a trade secret protection, and it's process oriented. We will document that in a way that is kind of like a patent application, and that's just sort of held on file with the company as this documentation in time, this snapshot in time of what this trade secret is. Clearly you limit access to that. That's, 2 or 3 people should probably ever see that. But that's one way to help document it. And if there is some trade secret misappropriation, in this context, it would be an employee who left, and you think they're stealing trade secrets and going to start this new process. Well, in court, you bring this documentation out. It's witnessed by people that maybe aren't necessarily inherently involved in the creating of the trade secret itself. It's pretty good evidence that you had this trade secret at this time.